Welcome to Wild HOA Situations. The vendor showed up fast because she kept them paid. Karen waved my guest pass and shouted that handwritten passes were fake by default. "I need your signature," she said, jabbing a clipboard at my chest like it was a warrant. Rain dripped off the brim of my visor, and I could see the tow truck idling at the curb behind her. Amber lights painting the wet asphalt orange. My car was in my driveway, same spot it had been for 3 months. But somehow 3 inches of bumper past the property line had become a federal case for Christine Evans, board secretary of Whispering Pines HOA Incorporated in Novi, Michigan. I worked nights as a UPS-style delivery driver, and the last thing I needed was a tow bill or a lien threat, screwing up my refinance closing in 2 weeks. Christine tapped the clipboard again. "I do not need your explanation. I need your payment." She always said it like that, clipped and cold, like she had rehearsed it in front of a mirror. I glanced past her at the tow operator, a heavy guy in a neon vest, already unspooling the wheel lift chain. This was escalation step 1, a vendor sent to my door to verify parking compliance and provoke a reaction. I had seen Christine do this to 2 other neighbors in the past year. Both folded and paid within 48 hours. I kept my voice level. What rule am I violating? Christine flipped a page on the clipboard and pointed to a highlighted section in a ring binder full of highlighted parking rules she called the standard. Section 12-4-B. Obstruction of pedestrian right-of-way. Your vehicle extends beyond the driveway edge into the public sidewalk zone. I looked down. There was no sidewalk. The property line ended at a strip of grass, then the curb. No concrete path, no marked walkway, nothing. I said, "There is no sidewalk here." She smiled, thin and sharp. "The code defines right-of-way as any transitional zone between private property and street infrastructure. Your bumper is in that zone. I have done this before and people fold every time." The tow operator stepped closer, hooking the chain under my front axle. I held up one hand. "Wait." I looked at Christine. "If you tow this car, I am going to file a dispute with the management company and request a hearing." She laughed, short and mean. "Good luck. Hearings require a quorum, and we have not had a quorum in 6 months." I took the fine notice she shoved at me without flinching, because I knew what it would trigger. The notice listed a $100 obstruction fee, plus a $50 administrative charge, plus tow and storage if the vehicle was not moved within 1 hour. I folded it into my pocket and pulled out my phone. I took 3 photos: the bumper position, the grass strip, the curb. Christine stepped into the frame. No photos of me. I lowered the phone. "I am photographing my property in the street." She turned to the tow guy. "Hook it." I stepped back. The chain tightened with a metallic groan. I said, "I am going to call the police and report this as a disputed tow." Christine folded her arms. "Go ahead. They will tell you it is a civil matter." The tow operator glanced at her, then at me, then kept working. I dialed. Dispatch picked up on the 3rd ring. I explained the situation: HOA ordered tow, disputed violation, vehicle on private property. The dispatcher said an officer would come by to document it, but they could not stop a contracted tow unless there was evidence of theft or fraud. I thanked her and hung up. Christine was already walking back to her car, a silver crossover parked across the street. She called over her shoulder, "You have until Friday to pay or we file a lien." 2 neighbors stood on the porch next door, whispering while pointing at the chalk marks by the tires. One of them was Malik, the community mail carrier who had seen Christine posting notices repeatedly over the past few months. He gave me a small nod. I waved. The tow operator finished hooking the wheel lift and started the hydraulic whine. My car rose 6 inches off the pavement. I took another photo. Christine drove off without looking back. The cop showed up 15 minutes later, a Novi PD patrol officer with a tablet and a tired expression. I handed him a clean packet, my deed, my property survey, my HOA payment confirmations proving I was never delinquent despite their fee blast, and a printed satellite image showing no sidewalk existed in this section of the development. I said, "I need an incident number for my records." He wrote it down, took his own photos, and told me I could dispute the tow with the yard and file a complaint with the county if I believed the fee was improper. He also noted that the HOA had no authority to define new right-of-way zones without a recorded plat amendment. That detail would matter later. The tow yard was in Farmington Hills, a 20-minute drive. I called them before I left. They told me the release fee was $370. Tow, first-day storage, and an administrative hold placed by the HOA. I said the hold is disputed. They said, "Take it up with the HOA." I said, "I will be there in 30 minutes with a check and a legal demand." The clerk paused. "We close at 9. I made it by 8:40. The yard was a fenced lot behind a truck repair shop, lit by sodium lamps that turned everything yellow. My car sat in the second row, still hooked to the wheel lift dolly. I walked into the office and set my folder on the counter. The clerk, a woman in a Carhartt jacket, glanced at the police incident number on the top page. I said, "I am disputing the tow." The vehicle was on private property, no violation occurred, and the HOA secretary has a history of targeting owners without cause. She is also claiming a right-of-way that does not exist. I need a receipt showing the hold, and I need the name of the tow company owner. She looked uncomfortable. I just processed the releases. I said, "Then process this one. I am paying under protest, and I am filing a complaint with the State Consumer Protection Office tomorrow." She printed the receipt. I drove home at 9:10, $370 poorer and angrier than I had been in years. The refinance closing was in 12 days. Any lien filing in that window could blow up the deal, and Christine knew it. That was the game. She did not care if the rules were real. She cared about pressure. The next morning I went to the township building and pulled the recorded plat for Whispering Pines. The development had been platted in 2006. No pedestrian right-of-way easements were marked on any interior lots. The only sidewalk requirement applied to perimeter streets, and those had been completed in 2008. I made copies. Then I went to the county clerk and requested all HOA meeting minutes and recorded amendments for the past 3 years. It cost me $40 and 2 hours of waiting. But I got them. That was when I found the first crack. The parking rule Christine had cited was part of a 2022 amendment that had been voted on at a meeting where the recorded attendance showed only 4 board members present. The bylaws required 5 for a quorum. The amendment was invalid. I called my attorney that afternoon, a real estate lawyer I had used for the home purchase. I explained the situation. She listened, asked 3 questions, and then said, "You have a strong case for reversal, but it will take time. If they file a lien before your closing, we can get it removed, but it will delay everything." I told her about the quorum problem. She said, "That is your trump card. If the rule is not valid, the fine is not valid, and any lien based on it is fraudulent. Document everything, and do not pay another dollar until we are in front of a judge." If you are enjoying this story, hit that subscribe button so you do not miss the next chaotic HOA showdown. I spent the next 2 days gathering evidence. I pulled my payment history from the HOA management portal. Every monthly assessment had been paid on time. No exceptions. I printed the transaction confirmations. I also found something strange. The violation notice Christine had given me listed my license plate number, but the last digit was wrong. She had written down a 7 instead of a 2. I checked the photo timestamp on the notice. It had been taken at 11:30 at night, 2 weeks before the tow. My car had not moved in that window. I pulled my work schedule. On the night of the photo, I had been on shift until 6 in the morning. The car had been in the driveway the entire time. I called Malik the next afternoon. He came over after his route and sat in my living room with a cup of coffee. I said, "I need to know what you have seen." He nodded slowly. "I have seen Christine walking the neighborhood at night with a clipboard and a flashlight. She takes photos of cars, guest passes, anything she can use. Last month, she tried to ticket someone for a crooked permit decal. The owner had to fight it for 3 weeks. I asked if he would be willing to write a statement. He said yes. Friday came. Christine sent an email to every owner in the development subject line parking compliance reminder. It was a mass threat disguised as a newsletter. All guest passes must be issued by the board. All vehicles must display current decals. All driveways must maintain clearance from public zones. Violations subject to immediate tow and lien. I forwarded it to my attorney. She replied within an hour, "This is harassment. Save everything." Saturday morning, I got a knock on the door. It was Christine, flanked by another board member, a retired guy named Gary who always looked like he would rather be golfing. Christine held her clipboard. She said, "We are here to verify your compliance status." I said, "You are here to harass me." She smiled. "We have the right to inspect common area adjacency under Section 9-2. I stepped onto the porch and closed the door behind me. "There is no common area adjacent to my property." She pointed to the grass strip. "That is a landscape buffer maintained by the association." I said, "Show me the plat." She did not answer. Gary shifted his weight and looked at his shoes. Christine tapped the clipboard. "We also need to address your guest parking." I said, "I have not had a guest in 2 weeks." She said, "You had a vehicle with a handwritten pass displayed on October 3rd. That pass was not valid." I stared at her. "That was my brother. He visited for 2 hours. She said, "Handwritten passes are not recognized under the current guidelines. All guest passes must be printed and issued by the board office." I said, "There is no board office. We have a management company." She said, "The management company acts on our authority." I said, "Show me the rule." She flipped through the binder. I waited. She found a page and turned it toward me, finger on a highlighted line. I read it. The rule said guest passes must be displayed in a manner visible to compliance personnel. It said nothing about handwriting. I said, "That does not say what you just said it says." Christine snapped the binder shut. "I do not need your explanation. I need your payment." Gary cleared his throat. "Christine, maybe we should." She cut him off. "No. This owner has been non-compliant for months, and it stops today." I looked at her. "You targeted the wrong plate number." I took the fine notice out of my pocket and held it up. "This says plate number ending in 7. My plate ends in 2. She froze. Gary leaned in and looked at the paper. Christine snatched it back. "That is a clerical error." I said, "No. That is evidence you were targeting someone else and then tried to backfill the violation when you realized your mistake." Christine turned and walked down the steps without another word. Gary followed, glancing back once with an expression I could not read. I went inside and called my attorney. She said, "That is your twist. Document it, photograph the notice, and we will use it at the hearing." I said, "She told me there has not been a quorum in 6 months." My attorney laughed. "Then there has not been a valid vote in 6 months. Every fine, every rule change, every enforcement action is void." Monday morning, I received a certified letter. It was a notice of a surprise hearing scheduled for Wednesday at 7 in the evening, location listed as the community clubhouse. The letter said I was required to appear to address multiple violations, and failure to appear would result in automatic escalation to lien filing. This was escalation step 2. A surprise hearing where they would try to prevent me from speaking at all. I forwarded the letter to my attorney. She called me within 10 minutes. "Do not go alone. I will be there. Bring every document you have." I called Malik and asked if he could come as a witness. He said yes. I printed 2 copies of everything: the plat, the meeting minutes, the quorum log, the payment confirmations, the police incident report, and the notice with the wrong plate number. I put it all in a binder. Then I made a 3rd copy and mailed it to the management company with a cover letter requesting an investigation into improper enforcement actions by Board Secretary Christine Evans. Wednesday arrived. I got home from my shift at 4 in the afternoon, showered, changed into clean clothes, and drove to the clubhouse. It was a low brick building near the entrance to the development, with a gravel parking lot and a faded Whispering Pines sign out front. My attorney was already there waiting by her car. Malik pulled in 2 minutes later. We walked in together. The clubhouse interior was a single large room with folding tables arranged in a U shape. Christine sat at the center table with Gary and 2 other board members I recognized but did not know by name. A 5th chair was empty. No quorum, I thought. My attorney sat down next to me at the single table facing the board. Malik took a seat in the back row of chairs. Christine did not look up. She was writing something on her clipboard. At 7 sharp, Christine called the meeting to order. She said, "This hearing is to address ongoing violations by the owner at Lot 42. The owner has failed to maintain driveway clearance, failed to comply with guest parking protocols, and failed to respond to multiple notices." I raised my hand. Christine ignored me. She continued, "The board has documented these violations over a 3-month period, and we are here to determine the appropriate penalty." I stood up. My attorney put a hand on my arm, then stood with me. She said, "Before we proceed, I need to address a procedural issue. How many board members are present tonight?" Christine looked annoyed. 4. My attorney said, "Your bylaws require 5 members for a quorum. Without a quorum, you cannot conduct official business." Christine said, "We have a provision for emergency hearings." My attorney said, "Show me the provision." Christine flipped through the binder. She did not find it. My attorney said, "I will make this simple. You have no quorum, which means you have had no quorum for at least 6 months. Every enforcement action you have taken in that period is invalid, including the tow, the fine, and this hearing." Christine stood up. "That is not how this works." My attorney opened her folder and pulled out the meeting minutes. She slid them across the table. "These are your recorded minutes for the past 3 years. On September 12th of last year, you voted to amend the parking rules. 4 members were present. No quorum. The amendment is void." Christine said, "We had a proxy." My attorney said, "Proxies are not allowed for rule amendments under Michigan non-profit law. You know that." I stood again. I said, "You also targeted the wrong license plate." I pulled out the fine notice and set it on the table. Christine grabbed it. I said, "That plate number does not match my vehicle. You took a photo of someone else's car, realized your mistake, and then tried to tow mine to cover it up." Gary leaned forward and looked at the paper. He said, "Christine, is that true?" She said, "It was a clerical error." I said, "It was fraud. And I have the payment records to prove I was never delinquent on any fees. I have the plat showing no sidewalk right-of-way exists. I have the police report documenting the disputed tow. And I have a witness who will testify that you have been harassing owners for months." Malik stood up in the back. "I can confirm that." Christine spun toward him. "You are a vendor. You have no standing here." My attorney said, "He is a resident and a witness. He has every right to speak." Christine slammed the clipboard on the table. "This is not a trial." My attorney said, "No, but small claims court will be. And when we get there, all of this evidence will be admissible. The judge will see that you used your position to target an owner with invalid rules, improper procedures, and falsified documentation. You will lose, the HOA will pay costs, and you will be personally liable for harassment." Christine sat down hard. Gary looked at the other two board members. One of them, a woman in her 60s, said, "I did not know about the quorum issue." Gary said, "Neither did I." Christine said, "We can cure it." My attorney said, "You cannot retroactively cure 6 months of invalid votes. The rules are void. Every fine is void. Every tow authorization is void. You owe my client a refund. And you owe the county an explanation." Christine stood up and walked out of the room. No one stopped her. Gary exhaled slowly. He said, "I think we need to call the management company." My attorney said, "I already did. They are reviewing the case. If you want to avoid litigation, I suggest you vote to rescind every enforcement action against my client, refund the tow fees, and remove any lien threats from the record." Gary nodded. The woman in her 60s nodded. The third board member, a younger guy who had not said a word, nodded. Gary said, "We will draft a resolution tonight." My attorney said, "Good. I will expect it in writing by Friday." We left the clubhouse at 8:15. Malik walked with me to my car. He said, "I have never seen anyone take Christine down like that." I said, "She made it easy. She got sloppy." He laughed. I drove home and slept better than I had in weeks. Friday morning, I received an email from the management company. The resolution was attached, all fines rescinded, tow fees refunded, no lien filing. The email also said Christine Evans had submitted her resignation as board secretary, effective immediately. I forwarded the email to my attorney. She replied with a thumbs-up emoji and a note. "We are not done. File the small claims case anyway. They need to learn this has consequences." I filed the case the following Monday. I claimed the tow fees, the attorney consultation fees, the filing costs, and a demand for the HOA to publish a formal retraction. Christine tried to respond with a counterclaim, saying I had damaged HOA property by parking improperly. The judge threw it out at the first hearing. She said, "The parking rule you are citing does not exist. Your authority to enforce was void. You owe this man everything he is asking for, plus court costs." The HOA paid within 30 days. Christine was not present for the final hearing. She had already moved out of the development. But the story did not end there. 3 months later, the annual board election arrived. A neighborhood group that had been quietly organizing for a year decided to run a slate of reform candidates. I was not involved directly, but I shared my story with them. They used it as a rallying point. The election flipped the board completely. Every incumbent lost, including Gary. The new board hired a new management company, rewrote the parking rules with actual legal review, and published a transparency report showing that Christine had issued more than 60 improper fines over 2 years. 37 owners received refunds. The tow company lost its contract. I also learned something else. Christine had been doing this in 2 other developments before Whispering Pines. She would join a board, take over enforcement, and use the threat of towing and liens to pressure owners into paying bogus fees. She had been quietly pushed out of both previous communities, but no one had ever taken her to court. I was the first. When the State Consumer Protection Office opened a case file based on my complaint, 2 other owners from those earlier developments came forward. The investigation is still ongoing. As for me, the refinance closed on time. No liens, no delays. I kept the binder of documents on a shelf in my garage, just in case. I still see Malik on his route. He waves every time. The new board sent me a thank you note for helping expose the enforcement abuse. I framed it and hung it in my kitchen. And every time I pull into my driveway, I park exactly where I always did, bumper 3 inches past the property line. Because there is no rule against it. There never was. I hope your notices stay non-existent.